Law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created, as you know, to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect your family, your business, yourself. We provide information and resources to help you decide whether or not you might be able to handle some problems, some cases, some issues yourself. Perhaps we'll help you determine when you do need to consult with a lawyer, how to best do that. In either case, you'll be better prepared, and so will the outside counsel that you select. Our goal, of course, is to help you save time, money, and hopefully achieve better results. As always, we want to thank the Bazar and Associates law firm in East Providence for continuing to provide their perspective and their insights on the issues that we tackle, and we welcome David Bazar.
Thank you, Deb.
Okay, so today, David, in the news, as they say, ripped from the headlines, the Apple versus the FBI. There are legal arguments, and it's certainly a nasty conflict. Apple has attacked the FBI's iPhone unlocking request, and they have several legal fronts. We'll go through those. The FBI's request for Apple to write new software to defeat the password protection program, it violates the company's thoughts about free speech. They're saying that computer software actually is an issue of free speech. We'll discuss that. And also their rights to due process, another issue, this according to Apple. On one side, we see that Apple may actually be doing something that's self-serving. They're certainly taking an unlikely stand in the consumer's right to privacy. They're certainly helping themselves. This is getting to be political. So they're standing up to the FBI, a federal district court judge, and I guess by extension, the U.S. government. So as of this session, and things do change daily, all we know is this. A federal judge in Brooklyn says the FBI cannot force Apple to open that locked iPhone used in a suspected drug dealer. Apple's win doesn't have any no direct bearing on the San Bernardino case, but we'll see how that happens. So we've got privacy, we've got security, we've got First Amendment, Fifth Amendment, policy debates, legal debates, bigger issues. Where to begin? Where would you like to begin?
Well, I think where we should begin is by framing what the issue is, which is really privacy rights, liberty rights of people, citizens, versus national security.
Okay.
And that's really what the San Bernardino issues are about, and the broader issues, really what the FBI versus Apple concerns are. And since I'm the only one here to talk about these things with you, I guess I'll just take both sides.
Okay, because I was going to ask both sides. One, if you were also one who happened to be defending Apple, but let's go with that. So privacy, of course we care about that. Security, we care about that. Terrorism, we care about that. So the FBI seems to say, we've got a great case here. You should absolutely help us by helping us to get access. Is it that simple, David? Care to comment on that before we get into some of the legal things?
Well, let's talk about it in the broadest sense first, I guess. Anytime and we've seen this throughout U.S. history, you run into situations where there are things going on in the world that create concerns. And we can go back to 9/11 and the towers coming down and the Patriot Act. And the Patriot Act giving some broad sweeping rights to the government to gather data and do things in the name of national security versus the liberty interests of people, their due process rights, their privacy rights being infringed upon. And the pendulum will swing back and forth as these things develop. Of course, right after this happened, I think the general sentiment of the public was we'll give up a little bit of rights for that protection, because one of the most important things a government can do for its people is to protect the people. However, what happens is the pendulum swings, sometimes it goes too far, and then you have Edward Snowden, I think was the fellow's name, saying, well, you really should know what's going on here, and the sentiment swings the other way and saying, we don't want the government sweeping in and taking away all of our rights this far and doing as much as they're doing, giving up all of these liberties and privacy rights, flies in the face of what we're trying to protect. In other words, the sentiment might be, you are giving up too many rights in the name of national security, so what you're trying to protect, you're giving up to try to protect it, and that's not a fair trade-off. And so the pendulum swings back and forth. Then you have the San Bernardino issues and the threats and attacks, and trying to track down the terrorist aspect of that in the FBI, and so that brings us to where we're at with that case.
There are so many issues that have been brought up with this, so I'm glad that we're starting to get into this. At one level, does it ever make sense that the government can demand that a private company do their work, force them to write the code that then undermines the very product which they have tried to build and advocate as being a very secure product? Never mind what it does to their market position, but can the government ask or demand that a private industry spend that time and that resource to do their work?
So I don't think, well, let's start with this. From Apple's perspective on the case, they're being asked to actually create something, as you said, that
Yes.
doesn't exist. So they would have to spend time, money, and resources to do that.
7 to 10 people, 1 month, apparently.
Okay. And can the government force them to do that? I really don't think the government can force them to do that from a legal standpoint. Now, we're not talking about the privacy issues here.
No.
We're not talking about the national security issues here. We're talking about a government saying to somebody, you are going to do this for us free of charge. So the free of charge part then becomes a part of the issue is why should a corporation, and now this is a big corporation, obviously they can afford to absorb the cost of it.
Yes.
But if they can do that to Apple, what about the mom and pop technology store where the guy is a sole practitioner, say, so to speak, from a legal standpoint, and he is just an extraordinary mind in a particular field, and the government wants him to create something for them? And can they come and say, you got to now spend next month working on our project and nothing else, no fee, no money, and you are going to have to put your family and your finances at risk? So when you look at it from that perspective, I don't see how the government could demand of a company to do something like that from just a strictly due process, it's like taking a property without due process. It's that type of Fifth Amendment issue, I think, that could be raised with that.
That's exactly what Apple is saying. It puts an undue burden on them. And then there's this other thought that has recently surfaced, which is that FBI has been found to have mishandled the case. They are claiming that even if they didn't make a mistake, they would still be needing to reach out to Apple. But essentially, with the way some of the hardware, some of those iPhones and other phones are set up so that if you try and miss 7, 8, 9, 10 different times with those passcodes, you have automatically hit the erase button. Too bad, that means it's irretrievable. So of course I can understand why the FBI wouldn't want for that to happen. But Apple came back apparently, David, and said that they should have known, and they did have other options, they just didn't handle it properly. And then again, that sort of supports Apple's case of saying, why should you put undue burden on us when in fact you made a few mistakes that perhaps you shouldn't have. Ask a 10-year-old, you probably wouldn't have,
right.
But that's another story. Sorry for the commentary.
That's all right. Well, and we can get into the other issues as we go along about whether or not Apple, whether the government has the right to ask Apple to do this, the national security versus the privacy rights of customers and all of that, and how that impacts on Apple. But to go back to your point, it seems that it's come out more recently that Apple has said to the government, you know, you could have done certain things differently and maybe we could have gotten this information for you. And I think in the past they have off of the iCloud. I'm not 100% technology driven and don't know it that well, but it seems that from what I've read and understand that the FBI had the county of San Bernardino change, because they own the phone in this case. I believe the phone's owned by the company, the agency that the terrorist, alleged terrorist, worked for. And it wasn't his private phone, it was an employer's phone. And the employer obviously would give the government all the rights in the world to access to the phone, get whatever information they can. And as I understand it, they had the county push sort of the reset button on the password for the cloud, the iCloud or whatever
Yes.
it's called. And if they hadn't done that, Apple might have been able to retrieve the information off the cloud that was
Yes.
on there, and we wouldn't really be in this situation. I don't really think that that impacts as much as Apple might think Whether or not they should still be required to get the information, I think their other arguments are stronger. But it really is interesting that, and the government's admitted, yeah, we told them to do that. It was our fault. We made a mistake. Unfortunately, there's still that opportunity no longer exists for them to get the information off the cloud because of that.
Yes, and interestingly, while this has been the topic that's been hitting the headlines, this isn't the first time that Apple has, in fact, helped the government or helped security or helped police try to crack a passcode. That's
Right.
very different from writing the software that cracks a passcode.
Right.
And of course, is this really just and only about this one case, or does it not, in fact, once they write that code, open the door and leave it forever open because you can't unwrite the code?
And that is one of the big issues in that case. It's whether or not it's strictly about this phone, this investigation, and this case, or does it open the door for all sorts of other cases? And even the government's admitted that it's not just about this case. Sure, if we get that code and we're able to do it, we will use it in other cases, and of course they would. But it's interesting because Apple is saying, you know, we, in the right situation, right circumstance, are not adverse to helping the government in a prosecution of a case, obtaining evidence for that case, and as you said, have done it before. They've given information off of the iCloud or allowed access so that information can be given so that the government can get whatever data they're looking for in a particular case under the right circumstances with the right judicial intervention where there are court orders and warrants and there's no search and seizure issues under the Fourth Amendment, and all of those protections are guaranteed. Once this code is just put into the government's hand, is the government then going to, on each case voluntarily, go back to the court and say, I need a warrant for us to be able to use this code cracking code that we already have, or are they just going to use it? And again, that's maybe part of Apple's concern, but it is more of the concern, at least, of the privacy advocates and so forth on Apple being forced to write a code that the FBI would then have unlimited access to.
And of course, by the same token, if the FBI is saying this is about terrorism, so of course that enlists the support and the concern of people, you know, nationally, as you pointed out, since 9/11. But of course, if that code is written and the FBI gets to use it, who's to say that true terrorists or other kinds of criminals couldn't also find that backdoor, and they would have created as much or more of a problem than they would have in just opposing this. So there certainly is, there's a political stand there, there's a legal issue, and I'm not sure how, obviously we don't know how this is going to be playing out, but it certainly seems to have been bigger than these two cases in New York and in San Bernardino.
Right, and so from Apple's perspective, it's about creating this backdoor, as they call it, into the security protections that customers and consumers have in their products. So it's a very important and big marketing issue to them because they say the security of their devices is really one of the things that customers need to know is inviolate,
Good point.
so to speak.
That's right.
And so it's got that customer issue. It's got the privacy issues that, you know, whether or not that's Apple's concern, it's certainly a concern of consumer advocates and privacy advocates that the government shouldn't have unlimited access or backdoors into people's private lives. And so you have that side of it, and I said I would take both sides. From the FBI side of it, from this case in particular, you have a phone which may, we don't know because we don't know what's in there and what this person used it for, but may contain some contacts to other people who are involved in terrorism and maybe linking it back to ISIS and whatever connections there may be to that the government could use to either stop or investigate other potential threats. And so the government needs to take it very seriously, and they are, of course, and has a very good argument as to why, in this case at least, it's really important for them to try to find every avenue of communication and information and data that's available to them.
And of course, it certainly seems like they are really reaching, they meaning the FBI, when they're calling on something that's, let me quote, All Writs Act, something that dates back to, what was the number, late 1700s, that allowed the courts to take any necessary and all appropriate aid to get whatever they need to help their case. And I guess just hearing that says that they are certainly fairly desperate in wanting this information and see what its potential is. And all the more reason why I can see somebody like Apple or any other large company wants to draw their line and say this can't happen. So does this, not to have this become a constitutional issue, but does this now have to go to a congressional debate, as some of that Judge Orenstein, I guess his name was, as he was claiming, this needs to be fleshed out, because how can you just rely on what was written in the 1700s when there was not such technology that would allow them to have such a wide sweeping net? Do we have to have a political or a legal debate on what was really meant by the founding fathers in 1700 to determine whether or not the FBI can actually reach and grab into Apple's intelligence or whatever?
So it raises a number of different issues. We always grapple with the issue of applying the law that we had in the past to the changes in technology.
Yes.
And I've often said it's the same principles that have to be applied. So when we talked about a wiretap on a telephone, and then we had cellular phones and communications being done sort of wirelessly, and the government able to listen to that, what is the role of the court in giving writs or warrants or whatever information, and what has to be done and doesn't have to be done? So I think it's really a matter of, in some ways, the court just following its own precedent and applying it to changes in technology in some ways. In some ways, Congress can weigh in on what was meant and what is important, and do the weighing and balancing of national security versus privacy rights. So there's a number of different avenues that these things can go. The court does have precedent to rely on, and it does have the interpretations of the All Writs Act, and what does that mean, and what are we allowed to do. But I think the bottom line is it's the same debate, whether it goes to the court or the government or the legislature or whatever it is, as to how do we apply laws to the changes in technology.
And so what's likely to happen? Is it about a public debate, and then have, out of that, the states and even the federal have Congress enact new laws to, do I want to say interpret or to clarify? Let me use the word clarify, how this sits in 2016, 17, and how does that work, David? What's going to happen for us?
It really works the same way it has always worked. If Congress wants to pass a law saying that the government can compel private business to provide services to the government, they can pass that law. But then the law has to be held up as constitutional, so the courts will then again have to interpret the law versus the constitutionality of the law, and does it violate the Fifth Amendment? Does it violate any issues in the Constitution? And it goes back to Madison versus Marbury, which was the case way back when that said that the Supreme Court or the courts have the right to judicial review of congressional and presidential actions. So judicial review will still apply, and whatever direction Congress goes in on trying to pass laws that might affect this area will be subject to judicial review. So in the end, the court still needs to interpret what are the rights of the citizens versus the national security issues, and weigh and balance those. And it's a weighing and balancing system that the court has used for years and years and years in determining privacy rights versus the right of the government to infringe upon those rights. I remember being in law school, and I'll tell you how far back that goes, is we were just starting the debate about the government saying that you can force people to wear seatbelts. And I had roommates in law school, housemates actually, debating this with me back and forth. What is the government's right to enforce the right to wear safety belts and infringe on your right to just be free to drive a car as you want to drive a car without those restraints? And so the one side of the argument is that's your own personal decision. The other side of the argument is, does your personal decision impact the rights of other people to be safe? And so it was back and forth and some really interesting arguments, but it's the same type of weighing and balancing argument that's being used there that would be used in these issues.
Good points. Interesting to hear that. So as I opened up the show, we talked about or mentioned what the story was in New York. But whatever happens, is it not true that this is going to go through an appeals process that's as long as my arm? I assume whoever wins, the other side will appeal. What's that process? I read something about there's appeal, there's a district, then it's to another circuit court of appeals, and then back to something else, and then to Supreme. How does that play out, David?
So it could play out in a number of different ways. So let's just talk a little bit about, because you did open and I didn't ignore you, but I didn't address the district court in New York saying that, remind me, that Apple did not have to provide information.
Is not compelled to provide that information.
And so the issue is, does that have any
direct bearing,
precedential bearing on the San Bernardino case? And the answer is really no, because it's one district court writing an opinion, and the other district court isn't really bound by that opinion. What is precedential value of what is binding on a case, for this instance, would be Supreme Court decisions or circuit court, perhaps cases that haven't been appealed to the Supreme Court. Those are of some precedential value, but binding authority would be from the Supreme Court. So that we'll talk a little bit about what is the process of appeals in this case. So a district court judge, a federal district court judge, makes a decision. That decision then is appealed to the Circuit Court of Appeals for that area. That case can be heard by a 3-court panel. We talked about the Tom Brady case before. I think his argument before that 3-court panel is coming up soon, or just came up, or is being heard fairly recently or soon. I don't remember which. In any event, so it can be heard by that 3-court panel. There can be a review, what they call en banc, which is the entire Court of Appeals. There's more than 3 judges in the Court of Appeals. The entire panel could hear that decision after the 3 judges decide it, if they feel it should be. And then it can be appealed from there to the Supreme Court, usually by writ of certiorari, which is a discretionary appeal to the Supreme Court, that the Supreme Court gets thousands of those and only decides to hear hundreds or a handful or whatever it is that they decide. So a case of this importance, I think obviously the Supreme Court would take it up, and that's how it would wind its way through the court system.
And that could take quite a long time, I would imagine.
It could.
But after that point, San Bernardino's going to be a moot case, I guess, by the time it goes to Supreme Court, maybe?
Not necessarily.
No, okay.
Not necessarily, because first of all, it would be still probable that there's information that they want to get.
They still might be able to extract something.
And secondly, the whole precedent of whether or not it can be compelled to be done will still be very important.
If you were Apple's lawyer, would you use the decision that came out of New York recently as part of the defense?
I would use the reasoning from that decision. So whatever the judge wrote as his reasoning for why it can't be compelled, certainly those are the types of arguments I would be making, and I think I would be happy to be buttressed by another federal court judge saying the same thing to this federal court judge.
And when the FBI makes a comment along the lines of, for their case, Apple doesn't want to do this because it will then lessen or weaken their market position. Never mind their product, but really their market position. Yes, it would weaken their product. Yes, it probably would weaken their product positioning as well. Is that a valid point to make in a case that has potential terrorism associated to it or with it?
I don't think that's a good argument for the government.
That's why I'm asking.
If I were the government's lawyer, I would be arguing more the national security issues. I would be arguing the power of the court to require them to do this, and I would be sort of trying to take away from their arguments about due process being violated and try to come up with an argument as to why it's not a due process violation, as opposed to whatever their marketing concerns are. I think you're actually strengthening their case by saying, oh, they're going to lose market share. Well, that's taking a property without due process.
And of course, what's also been discussed recently is, well, what about the positions of AT&T or any phone manufacturer as well as carrier? Well, the phone manufacturers would certainly like to see Apple not do as well. And there's been a time where software had been doing better than Apple. There was a Microsoft time in the 70s, 80s, and then there was Apple that's better. And now it's claimed that perhaps Google and Facebook might be doing a better job of security. And so they're using that as a possibility of part of an argument. Again, it's about a marketing situation there. But many of them have stayed on the sidelines, and they meaning the software or the carriers. People like Mark Zuckerberg, Facebook says, no, security really does matter,
Right.
and he certainly has a stake in security as well.
So you would think that Facebook and Google and Samsung, who makes phones, and other producers of phones, and all of these other folks would actually, if they did anything, want to come out on Apple's side.
Yes.
Because if it can be done to Apple, it can be done to any of them as well.
Yes, and that was one of the very interesting opinion pieces, that it would certainly make sense that they would all rally behind Apple, but many of them are keeping fairly silent at the time. So we'll see how much farther they push to make that happen. You brought up the Snowden situation as being one very big issue, and that was attached to AT&T, I believe. AT&T opened the door, but it wasn't about doing something like writing code.
No, I think that goes back to the government collecting I think they call it metadata, just massive amounts of data.
The backside.
Right. And so the government, through the different Patriot Act or whatever rights that were given to them, had the authority to start collecting from AT&T, Verizon, whoever it is, all of the data on individuals, but massive quantities of data, and then go through and analyze all of that data. And I think the whole thing with Snowden was, he was saying, you have no idea how much data is being collected, and he started releasing private government information as to what was being done. And again, that was sort of my beginning thing about the pendulum swinging back and forth, because there are really legitimate arguments on both sides of this issue, national security versus privacy. And although I told you I'm the only one here and would argue both sides, I will tell you that individually, as I sit here, I can see the argument on both sides, and that's why it's easy for me to do that.
I think that there's certainly been so much written. You've done a very good job, thank you very much, of laying out what those issues are. This isn't going to be settled soon. We can tell it's going to be going on. We hope that this has been interesting and helpful to you. We think we have a good place to leave this now. We hope that you will continue to stay tuned to the Law Matters, because as it goes on, we have many more questions that have come up in possible topics in the short term. So we hope you will stay tuned to the Law Matters, because the law matters to you. Thank you.